Morning, everyone. I hope that you can hear me. If there's any problems, please shout on the chat at the bottom. I'd just like to welcome you to our leisure seminar. It's a virtual seminar, so I'm afraid I can't give you any coffee or bacon sandwiches that we had hoped to do if we were meeting in person. The reason why we did it virtually was that we'd had a really good response to this seminar, and it was clear there was an appetite for it. But if not the majority, certainly a large minority would have preferred to do it online. So that's why we switched to online, so that we could hopefully deliver it to as many people as possible. And as it turns out, it was a good for me, because I'm suffering from COVID at the minute, so I'm isolating at home. In terms of myself, I'm a partner, Ben Lamb, in the real estate department at Clarion Solicitors. And I also head up the leisure sector department sector at Clarion. For those of you that don't know, Clarion are a full-service law firm based in the centre of Leeds in Queen Street, and we've probably got about 300 people working for us these days. I'm glad this morning that we're hosting this jointly with Leeds Business Improvement District, or LeedsBID, who I suspect some of you will be aware of, and you may well be members of it through having businesses in Leeds city centre. LeedsBID was started in 2015. It's the largest business improvement district outside of London, with 650 businesses in Leeds city centre paying a levy to it each year, which is then spent on improving Leeds city centre. So if we had done this in person, we would have had it in the offices of LeedsBID, which has a tremendous view over Leeds city centre. So I'm sorry that you've got to put up with my background of my bookcase and a dormer window, but maybe next time that we do one of these, we'll do it at LeedsBID and have that wonderful view. I'm pleased to say that Andrew Cooper from LeedsBID is joining us this morning. He's the Chief Executive of LeedsBID, and he'll be summing up at the end of this seminar. So enough about us. What are we going to talk about today? Well, obviously, the leisure sector encompasses a massive range of operators. We've got bars, restaurants, hotels, bootmakers, theatres. I think one thing that you will all have had in common over the last 2 years is the massive impact that COVID has had upon you. I think the only certainty that there's been over that 24-month period is uncertainty. And certainly we've seen firsthand through assisting our clients the worries, concerns and difficulties that many of our clients have faced in the leisure sector. But also on the positive side, we've seen the incredible resilience of the sector and its ability to adapt to changing circumstances and keeping going no matter what is thrown at it. So here we are sitting on the cusp of spring 2022, hopefully with the lockdowns behind us, fingers crossed. The leisure sector continuing to open up with opportunities out there to be seized, hopefully. But we're still aware that there are challenges that the sector is facing. I think I read the other day that the pandemic was like a tsunami that rolled in and covered every other challenge and issue that there was, not just in the leisure sector, but in business generally. And as the pandemic starts to recede and that tsunami starts to roll out, the challenges and issues that were there and that were covered for the last 24 months will come to the surface again and need to be dealt with. Not least of which, I guess, are still the ongoing effects of Brexit and how that will work through. So I think it's important that the leisure sector recognises the challenges and manages the changes which will undoubtedly continue to happen, to allow businesses to adapt and to continue to evolve to these new challenges that will come along as the pandemic tsunami recedes. I think this morning we could have picked any number of topics really to talk about. We've alighted on 4 topics, which I hope have some broad resonance for you, and we should include some issues that I think a lot of businesses will need to deal with over the next 12 months or so. So we're going to look at employment, property, regulatory issues, and venue and space management planning. We've got 3 speakers this morning from Clarion, Suzanne, Sophie, and Sarah. And then breaking the hat trick of S's, we've got Richard Irving, who's joining us from ID Planning, who we've worked with for many years, and I'm delighted to welcome Richard to do the fourth slot. The last thing that I wanted to say was that you should have a little Q&A button at the bottom of the screen. And if you would like to ask questions, we'd be delighted if you would during the course of the presentations. Please use that function to do so. It's anonymized, so only the panel can see the questions. And what I propose doing is asking any questions that arise at the end of each speaker's slot. And we'll not say who asked the questions, so don't worry about any questions being daft. They'll not be attributed back to you, but please do join in. So without further ado, if I could ask Suzanne to do her presentation, which is on employment issues and managing the workforce.
Thanks very much, Ben. So as Ben has said, there's been a lot of challenges facing the sector. And I think, as most of you will be aware, one of the biggest issues that we're facing at the moment in the leisure sector and employers as a whole is the recruitment issue. So according to the Office of National Statistics, at the moment, job vacancies are at a record high. And now there are a range of reasons for this, but one factor is clearly due to the return of a large number of EU nationals to their country of origin. One particular survey conducted by the Caterer website said that they estimated more than 92,000 workers from the EU had left the hospitality sector between August 2020 and August 2021. So filling this gap is enormously important and has proven to be difficult because obviously we have a lower number or pool of candidates to recruit from, and therefore it's become a bit of an employees market, with employees asking for higher rates of pay and more flexibility as the pandemic has worn on. So what I'm going to talk to you about today is a few ideas in terms of how you can challenge that and tackle that recruitment problem, and also how you can retain staff and motivate the staff you have in place after what Ben has highlighted has been an extremely difficult couple of years. So one way of tackling this issue is looking at potentially overseas recruitment. Now, this is not as easy as it once was. So following Brexit and the end of freedom of movement, unfortunately, we now no longer have access to a large European workforce at little or no cost. So what this means in practice is that if you want to recruit an overseas worker, including the European national, to come to the UK, you will need to obtain what's known as a sponsor license from the Home Office before you can employ that person. And that worker will then have to go and obtain a visa before they can come to the UK. Now, there are a number of routes available, but the key ones for our purposes today are a couple called the skilled worker visa and the intracompany transfer visa. So the skilled worker visa is essentially a visa whereby you would sponsor a worker who possesses the skills that are listed on those jobs that are eligible for sponsorship. So it's a reduced list. Not all jobs are eligible for sponsorship. And you will have seen probably in the press that there's been a lot of argument about how the government decided which jobs go on the list and which jobs stay off the list. And a perfect illustration of this is the HGV driver issue. That wasn't originally on the list, and then they set up a temporary scheme for that, which is now coming to a close. There's a minimum salary threshold, which may be more complex in businesses that are looking to recruit workers at a lower skill and lower salary level. So this is 25,600, or the going rate for the job. But there are exceptions to this, so you can pay less money if they're on a shortage occupation role or if they're a new entrant to the market. And there are also English language requirements for this visa. The second visa, which is pretty useful if you're an overseas international business, so you have businesses abroad and in the UK, you can bring staff in via what's known as an intracompany transfer visa. Now, the salary rates are higher there, and they do have to have service. So, for example, a standard visa, you need to have worked in the company abroad for 12 months. They also require skills at degree level. There are a couple of other routes that are in play as well. So, for example, we're looking at global business mobility visas at the moment, and the government is looking to set up a new route to give us more options for sending personnel from eligible overseas companies to the UK. But In most cases, you would be looking at the skilled worker or the intra-company transfer visa. And unfortunately, there are costs involved in sponsoring workers to come to the UK, such as the immigration skills charge, the visa costs, and the application processing time can be lengthy. You also obviously have to apply in the first instance to obtain a sponsor license, and that process in and of itself can be time consuming and costly. However, once you have got that, that is an asset for your business. That puts you at an advantage because you're able to go out and recruit beyond the UK into a wider marketplace. So in terms of practical steps that you could be taking now, you could essentially have a look at your workforce and the skills that are missing. If there are jobs that you are looking to recruit for in maybe the next 6 to 12 months and you have not had much success in recruiting for them at the moment, then it's probably worthwhile thinking about whether or not you need a sponsor license, seeing if that job is on the list of jobs eligible for sponsorship, and perhaps letting us know if you need any help with that process. If you already have a sponsor license, then you really need to be looking after that, because it really is an asset to your business, because obviously it allows you to recruit beyond the UK and to recruit the best and brightest from anywhere in the world. So if overseas recruitment doesn't necessarily meet the requirements of your business, perhaps the skill sets aren't on there, or they're not eligible for sponsorship, or the costs are too high, then there are other ways of recruiting in. So for example, a lot of our clients have been removing geographical barriers to work. So instead of advertising just locally next to the business or next to the branch, they're looking more widely to recruit beyond their local area, so allowing people to work remotely. Now that may or may not work with frontline roles, but it's certainly a way of expanding the group and the pool of candidates. It's quite common in this industry as well to have younger recruits, so seeking them out and either via graduate recruitment programs or taking advantage of the range of apprenticeship schemes that we have in place at the moment is a really pragmatic way of filling skills gaps. And there are obviously shorter term options now for apprenticeships, so you don't necessarily have to be tied in for very long periods of time. What I would say is when you do put apprenticeships in place, you have to be really careful to make sure you get the right documentation, because it's important to get it right the first time. Another interesting approach some of our clients have been taking is developing their links with local schools and colleges, attending open days and fairs there to try and look at recruiting perhaps younger workers. So some of our clients are recruiting under 18s, and this is a useful way of filling up seasonal gaps in employment, and also to develop longer term relationships with those individuals over a long period of time, offering potentially career progression from a very young age. And whilst it does involve it's important to note it does involve extra considerations, such as differences on right to work, working hours, etc. So you just need to make sure that you are following the law in terms of younger workers. An interesting approach that some of our clients are taking is offering what they're calling returnships. So perhaps people who've been out of the business or the sector for a while, offering them a short-term professional internship to reintroduce them back into the full-time employment with their former employers. Actually quite a clever way of getting that skill set back in and looking at using skills where people think they may have atrophied, but actually with a brief internship they can get those skills back up to scratch. Another area, of course, is looking at older recruits. There is a lot of evidence to suggest that people who've retired are now looking to come back to work in order to build up their pension pots. So easy gives, such as making generous pension contributions, can actually attract this generation too. So these are just some of the ideas of looking around to see what recruitment that you can undertake and ways of bringing people into the business. But what about retaining the staff that you already have? Well, obviously pay and benefits are a really key way of doing this, but that's not always going to be possible. You can't always pitch for higher salaries and benefits. Another potential easy give is flexibility. So in recent times, you'll be aware employees are really keen to retain the flexibility and agility that they acquired as a consequence of the pandemic. Obviously, that's not always going to be practical, certainly in frontline businesses, but if that's not possible, more flexible shifts or certainty, longer planning times on rotas have often helped a lot of our clients to try and retain staff and put in more flexibility around what shifts they have to do over certain pinch points. Simple gifts such as offering an additional day's holiday or holidays on birthday, holiday purchase schemes, staff kit discounts, away days, or prizes for staff can go a long way in rewarding, overworked staff or staff who've been demotivated. And as I said, expanding benefits packages aren't always as expensive as you might think. There are certain tax efficiencies that can be involved in offering health insurance or enhanced pay for family leave or higher pension contributions. I think it's really clear that progression in training is a really key issue. People are looking now for, careers, not necessarily jobs. So putting in place really simple things like appraisal systems, providing training where skills gaps are identified, can really, really help to make employees feel like they're invested in the business. Internal mentor schemes or coaching, and also issues around mental health. So a lot of our clients are doing things like, paying for a yoga teacher to come once a week, subsidized fitness classes or employee assistance programs. All of these things help to create a culture. And the culture in and of itself is what a lot of individuals are now looking for in terms of long-term staying with a business that they think reflects their values. So I think there's no doubt that there are some considerable challenges facing the sector, but I think some of those ideas and steps, which are very briefly outlined in the time we have, should hopefully offer you some helpful tips to overcome them. I think it's back to you, Ben, to see if there's any questions.
Thanks, Suzanne. That was really interesting. Yeah, we do have a question that's come in. The question is, how much does it cost to get a sponsor or to apply for a sponsor license? And how long would you expect to wait to get one?
Okay, well, it costs, if you're a small employer, so if your turnover is about less than 10 million and you've got 50 employees or fewer, then it's about £500 to apply. But if you're a medium or a large employer, it costs around 1,500. There are other costs involved. So you would potentially, generally speaking, the employer pays for the visa and other bits and pieces, but the initial cost is about 1,500 if you're a larger employer. And in terms of the period it takes, well, that's a good question. The Home Office is a bit snowed under at the moment. What they say is it would take 8 weeks to get a sponsor license, but sometimes they come quicker. So we have had them within 2 weeks, and you can sometimes pay an extra 500 to get a decision in 10 working days. So I think the key point is, if you are going to look at recruiting from overseas, it's really important to plan ahead so that you can factor in the timing for obtaining the sponsor license, then getting the visa to ultimately get the individual here. And that can take any time up to 3 to 4 or 5 months.
Brilliant. No, thanks, Suzanne. I should say that if anyone has any other questions that they want, we'll distribute, if we haven't done so already, everyone's contact details at the end of this session. And please feel free to contact the relevant person directly, who'd be delighted to have a chat with you about any questions that you might have on these issues. Thanks very much, Suzanne. Moving on to Sophie, who's going to talk about property and particularly rent issues. I know over the last 2 years there have been a lot of tenants who have reached accommodations with the landlords as to rental holidays and concessions, etc. But I think changes are afoot come the end of March, which Sophie is going to guide us through.
Right, thank you, Ben. Yeah, as Ben says, my name is Sophie Morley. I'm a partner in and the head of the property litigation team at Clarion. Don't be put off by the words property litigation. It basically means we deal with everything other than buying, selling and letting property. So any issues surrounding property come to us. It doesn't necessarily always end up in the courtroom. So I'm going to look at rent flexibility, and I'm going to break it down into 3 parts: where we are now, those changes that Ben mentioned that are coming in at the end of March, and where, with my crystal ball, I think we might get to in the future. So first of all, where are we now? I'm sure most of you will know that from March 2020, there has been a moratorium on forfeiture for non-payment of rent. So what that means is that the landlord's ability to forfeit or terminate your lease because you haven't paid your rent has been lost since March 2020. Just briefly, in terms of forfeiture, there are 2 ways a landlord can forfeit a lease. One is to make an application to court for an order that the lease be forfeit. And then the second one, which applies only in terms of non-payment of rent is that the landlord can go in and what we call peaceably re-enter, which is change the locks. So you turn up for work one morning and in the middle of the night, the landlord's bailiffs and a locksmith have been round, broken in, changed the locks and put a notice up with a contact number, and they will effectively only allow you back in when you've paid all your rent arrears. So that's a really, really effective tool if you're a landlord, and that is essentially what the government have stopped for the last 2 years. The current moratorium remains in place until the 25th of March this year. Current government strategies that we've seen seem to suggest that the government wants to be putting the pandemic behind them. So it seems unlikely that they're going to extend that, but it has been, I've said that a few times before over the last 2 years, to be fair. And we have seen it extended on sort of 12 hours notice. So watch this space, but I would be really surprised this time, you know, particularly when we're looking at the government is saying in March, you won't need to self-isolate. The pandemic is that much behind you. It would be odd to extend this, but they may yet do that. The consequence of this, of course, is that some landlords have gone 2 years without any rental income. Now, there's very few of them, as Ben mentioned. Most landlords, and in particular our clients, have got themselves to a position whereby they've had a conversation with their tenants. I'm sure you've all had conversations with your landlords of varying degrees of pleasantness over the last 2 years. Lots and lots of landlords and tenants have done deals. Some tenants have surrendered. And landlords have applied other pressures to terminate leases. So while you can't forfeit for non-payment of rent, you can for illegal assignment or failure to keep into repair. And if your lease was coming to an end, Section 25 notices have been served to try and push things forward. So there are very few landlords out there that haven't received any rent for 2 years. But if you are one of those tenants that hasn't paid any, then this is going to be really key for you, and your landlord will be chomping at the bit to come the 26th of March to take some action. One thing to mention, although I will only mention it very briefly, is CRA. It's a process that you may have come across whereby the landlord can come into premises and take goods to the value of the rents owed. Now, that process changed a few years ago and it's become really clunky, so it's not very well used, so I'm not going to focus on it, but just to say briefly that the current moratorium on that will also come to an end, we expect, at the end of March. So if your landlord's ever done that before or threatened it, then that risk becomes real at the end of March as well. So what's going to be the position from the 25th of March? Well, what the moratorium doesn't do and hasn't done at any point over the last 2 years is stop that rent accruing. So all rent owed at any point remains full, due and owing unless you and your landlord have agreed in writing otherwise. There is a government code of practice that's effective currently, which says that landlords and tenants are expected to negotiate and they're expected to give evidence of their position in those negotiations. So it's not simply good enough for a tenant to say, I can't afford to pay this. And it's not simply good enough for a landlord to say, I can't afford not to receive my rental income. Each party is expected to work together and provide evidence and negotiate. Now, where you can't negotiate, what the government have put in place going forward from the 26th of March is a legally binding arbitration process that is expected to come into force to bookend the end of the moratorium. We haven't got very much detail on it as yet, but as I say, the government's produced legislation on this in sort of 12 hours notice during this pandemic, so we expect it to come. So the arbitration process will apply only to what is known as ring-fenced arrears. And those arrears are those arrears that occurred during a period where your business was forced to shut due to government lockdown. And obviously the leisure sector is one that's been hit the hardest by those lockdowns, but also one that's probably found the biggest sort of amount of grey areas. And the one that I particularly think of is the run up to Christmas, whereby you were able to trade. There was no limits on anything like that, but Plan B was in force, and people were, particularly in the run up to Christmas, staying home as much as they could for fear of catching the Omicron variant and losing their Christmas with their family. So that period, for example, wouldn't be a ring-fenced arrears because you were absolutely able to open and trade. We know that the reality is that wasn't an easy process for most of you. Once a landlord has or a tenant have identified those ring-fenced arrears, then either party can apply for this arbitration process to start. You've got 6 months to do it, and you put together your proposals for what you think you can pay and when you think you can pay it. And then the arbitrator will look at both proposals from the landlord and the tenant and try to come to an appropriate decision based on some principles. I won't go into them in detail, but the principles are, for the most part, pretty sensible. So they are the number one priority is to preserve business and jobs. but only to preserve those businesses and jobs that are viable going forward. If the tenant can't pay but the business is viable, then the landlord is expected to make rent concessions. However, those concessions do need to be affordable for the landlord. So if there is any reason in particular the landlord can't afford it, that is key. Both parties need to show evidence of their situations, as with the current guidance on negotiations. A key one probably for tenants is that what they can afford is not allowed to include any assumption that they will restructure or borrow. So whilst any government loans that you took out can absolutely be used for rent or service charge payments, you can't be, the landlord's answer can't be, well, you can borrow more money. That's not acceptable, or you can restructure your business, or you can go into some sort of insolvency. That's not allowed as part of this process. In terms of service charge, which under some leases is treated as rent, it has to be sums actually accrued. So I'm sure quite a lot of you will have a lease whereby your landlord charges you a set amount of service charge every quarter, and at the end of the year does a balancing payment. Those balancing payments, if they're not actually accrued, can't fall in these arrears that the landlord is seeking. It's only money the landlord's actually paid out. And the final one is that there is expected to be forbearance from lenders, but the lenders, as far as we can see, aren't expected to be a part of this process. So there's a lot of grey area about how that might actually work in practice. So what do you need to do? I think the one thing I would recommend absolutely everybody listening to this webinar do is go back, look at your accounts, speak to your accounts team, and ascertain whether you have any arrears anywhere, pre-pandemic, post-pandemic, for any period. Work out where your balance sheet sits and what you owe. Some leases will include rent, service charge, insurance, VAT, some other random payments as rent. Others leases won't. It will literally just be your headline rent. So that will depend on your lease term. But if it is included as rent, it's all subject to the risk of forfeiture from the 26th of March. So once you've established if you have any arrears, then you need to look at whether those arrears are ring fenced. And those that are ring fenced and subject to this arbitration process, they're your less risky. So kind of don't worry about those. Prioritise massively those for the periods where you were allowed to open under government rules. There will be a risk of forfeiture. We do have landlord clients that are poised as of the 26th of March to go in and change locks to get their tenants' attention. There are some things we can do, security, well-timed interim payments, making payments confirming which period they relate to, corresponding with the landlord to try and get them to waive their right to forfeit. There are some steps we can take, but they're all on a very much case-by-case basis. But if you're concerned about that, let me know, we can look at it. So that's where we are currently, where we will be from March, and then for my crystal ball is where we will be going forward. I think much like Suzanne was saying, with things have changed and hybrid working and expectations have changed. I think expectations of landlords have changed a lot as well over the last 2 years. We want our rent, we want it every quarter. There's no talking about it. Is probably not the way forward for most landlords. So I think there will be some continued flexibility, but lots of landlords have gone through some very difficult times, and they will be looking to recover funds as and when they can. In terms of footfall in city centres, we're seeing that go up. It went back up in the last couple of weeks as workers started to return to the office. And when we're talking to clients, particularly landlord clients in city centre settings, they're holding a lot on leisure clients. They're finding that particularly ground floor retail spaces, they're hoping they're going to get leisure operators in. So you're in a really good position in that sector, that the landlords have faith that you are their way out of this, and they're way out of void units. So that will give you quite a good negotiating position. And the other thing to remember is you don't know what your landlord wants. So much as I say we've got landlords that want the premises back or want to get your attention by peacefully re-entering your property, we equally have landlords who are looking to remortgage or leverage, and the change of you losing a break clause or you extending your term for 5 years actually has a massive knock-on effect on those. So until you have that conversation with your landlord and know what their drivers are, there might actually be something you've got that you can easily give to them, which in return gets you that greater flexibility going forward. But the days of not being able to pay your rent and not and not risk forfeiture are coming to an end, if not by the 26th of March, very quickly thereafter. And that is something you all need to be very aware of. And as I say, as you leave here, I would advise that you all check your arrears situation. Are you in arrears at all? Do you owe any money to your landlord? And then work out where that leaves you in terms of the ring-fenced arrears and the other arrears, and prioritise those other arrears. And if making any payments, make sure they are labelled as payments for that particular period, so that you're aware that they're not going towards ring fence, which are your low risk arrears at this point. I think that's all from me, Ben, unless we have any questions.
Thanks very much, Sophie. No, that was really that was really useful. I mean, I think, as you touched upon, one of the impressive things to see during the pandemic was the sort of grown-up conversations that were had between landlords and tenants, which I suppose was a bit of a surprise to me. I act for both landlords and tenants, and usually it can be quite an adversarial relationship if there's issues with non-payment of rent. But on the whole, conversations were had in a very constructive manner, I think, and allowed a lot of tenants, you know, a lot of landlords allowed a lot of tenants help, which was very positive to see. And I'm hopeful over the next few years that those sort of resetting of relationships can continue. And as you say, constructive conversations can be had about a whole range of issues, but I guess the proof will be in the pudding. We did have one specific question, Sophie, which is to do with, you talked about the ring fencing of arrears. If you're a tenant and you don't know whether those arrears are ring fenced or not, how do you go about establishing whether they're ring fenced and therefore able to be arbitrated?
Good question. It's very, very easy for me to sit here and say, go and check your arrears, isn't it, if you don't know how to do that? So the first thing to do will be to request a statement of account from your landlord, because that should break down what is owed and which periods, which is the key part of it. If the landlord won't give you a statement of arrears, first of all, that's an alarm bell. So be very aware of that, and be aware that may be because they're seeking to forfeit. If you know what you've got, I mean, ideally, the position you then go into is that you pay your arrears, or you pay those arrears that you know you can allocate to those non-ring fence periods. But if the landlord won't tell you that, and you can't allocate your own records to it, or you've been paying monthly or sort of on an ad hoc basis with the landlord's agreement, then I think really your best risk at that point will be to assume a forfeiture, and then to look at the steps you can take to avoid that. So things I mentioned, such as some well-timed payments, some correspondence, or even putting 24-hour security in the premises so that the landlord can't go in and do that.
Thanks, Sophie. Thank you. Right, we're going to hand over to Sarah Taylor now, who's going to talk about regulatory compliance and managing safety and enforcement of risk in this continuing uncertain environment. Thanks, Sarah.
Thank you, Ben, and good morning to everybody. When I first started to think about what I should say in this section on legal compliance, I assumed I'd include something about mandating COVID passes. They were introduced, as we'll remember, on the 15th of December as part of Plan B COVID measures and efforts to tackle the Omicron variant. I imagine that I would have talked about the role that they would play in helping to deliver safety in the leisure environment and how they'd fit into a COVID risk assessment. But as Suzanne, of course, might have had something to say about the discrimination debate that had developed around them. But then on the 19th of January came the announcement that Plan B measures would be withdrawn, and as at 27th of January, the legal requirement for events and venues to require the COVID pass fell away. And that, I think, has been part of the experience of the last 2 years, hasn't it? There's been an ebb and flow of restrictions, prohibitions, and requirements. We've experienced different phases: the national lockdown, the Eat Out to Help Out scheme in the summer of 2020, the tier approach introduced that autumn, then steps 1 to 4 of the roadmap out of lockdown in 2021, and more recently Plan B. And for those operating sites outside England, there were very often differing requirements in Scotland, Wales and Northern Ireland. So in short, it can only have been a very trying time for you all. I think it's tempting to think that in England, at least, we may now be in a policy place that reflects a desire to live with COVID. And there have been signs, I think, recently that that may well be the case in the change to rules, for instance, on PCR tests, in the reduction in the number of days of self-isolation, in the return to Plan A. But perhaps it's still optimistic to think that there won't be any future phases of the pandemic that will test us again. Perhaps a new variant or a seasonal spike in numbers that bring about the resumption of some degree of control. So if that's right, what can we draw from this in compliance terms? And I think I'd like to answer that question with 3 points. First, to observe that from a strict legal perspective, it's been quite difficult to reconcile COVID risks with the traditional health and safety framework. Health and safety duties for employers are about protecting employees at work and about protecting non-employees from risks that arise from the way in which you run your business. Traditionally, that's been about managing the risks that arise from the workplace setting. For instance, from the way in which you unload your deliveries or move your stock, the way that you manage fire safety. It's not been about managing the risks arising from a pandemic, from a virus circulating in the community. And therefore, there's been some discussion about whether COVID risks can properly be enforced by reference to the Health and Safety at Work Act 1974, about whether the COVID risk really arises at work or from the way in which you conduct your undertaking, for it's those risks alone that the employer is obliged to manage. So to some extent, certainly the lawyers have been ready to take those points on behalf of their clients in order to try to deflect legal challenges. And it's still something I think that you may wish to bear in mind if you find yourselves attracting attention from regulators about your management of COVID risk at work. And I think, and this is my second point, I think partly because of this difficulty, there's been over this period relatively little formal enforcement related to COVID. The Health and Safety Executive launched a programme of what it called proactive COVID spot checks. Those were unannounced visits to workplace settings to see how employers were dealing with the challenge. As at last December, there had been over 345,000 spot checks, and where problems were found, they tended to be in relation to issues such as insufficient ventilation, lack of risk assessment, or inadequate hand washing facilities. In just over 12,000 of those cases, verbal advice was given by inspectors. There was written correspondence in 2,370 cases. In 365 instances, safety notices were issued, improvement or prohibition notices requiring action to be taken. But I'm aware of only one case that went on to prosecution, and that concerned a construction site in Manchester. The spot check there found a good deal wrong. A prohibition notice and 2 improvement notices were served. The return visit a few weeks later identified no real improvement, and in fact, an additional prohibition notice was served when fresh concerns emerged around excavation safety. The company was eventually prosecuted for failing to comply with any of the notices. The lead inspector in the case was very clear in what I thought were interesting post-conviction observations. She was very clear that the priority remained to work with employers to make workplaces safe from transmission risks. I think I'd be inclined to say safer, given the nature of the virus. But the priority was not, in her view, what she called heavy-handed enforcement. She went on to say, though, that consistent disregard for COVID risks and other risks would translate into formal action and the accountability of those responsible for the shortfalls. So I conclude from this that positive engagement with the regulators, dialogue, communication about the COVID controls that as employers you've implemented are all likely to be helpful in maintaining a constructive relationship and avoiding enforcement action. The third point, the final point, I'd be inclined to emphasise is the importance in these circumstances of following guidance. And this links to the difficulty of reconciling COVID risk to the normal health and safety framework. Because of the novelty of trying to do that, the guidance takes on, in my view, an outsized role. The contents of the relevant guidance are seen to amount to reasonably practicable steps to ensure safety. Implementing the guidance in turn allows the employer to say that he's doing all he can in the face of the COVID threat. If you're aligned with the guidance, what more can you reasonably do? It makes it very difficult for a regulator to say there's a compliance gap and to launch enforcement action. The government issued Working Safely guidance has been in operation since the early months of the pandemic. It's been updated recently and frequently to reflect the ebb and flow of restrictions. It's sector specific, so helpful in that sense. Also, the module that's addressed to restaurants, pubs, bars, nightclubs and takeaway services is likely, I think, to be relevant to a number of you. The most recent version of that, updated on the 27th of January, now identifies 6 main actions that can be taken to protect staff and customers. But we've tended to find that it's useful to view it as a checklist. So in that spirit, I'll flag those control measures very briefly. If Atlanta, you'll be kind enough just to display, please, the first slide. It captures these 6 priority areas. And the first of these is inevitably to carry out a risk assessment. If we could just move on, Atlanta, please, to there we are, the 6 priority actions. First of all, carry out a risk assessment, and that means identifying the control measures you're adopting in light of the transmission risk. It means recording them in writing, because that's a priority, a standalone legal requirement for any employer with more than 5 employees, and then keep them under review. We've found that it's been helpful to adopt some sort of document control for the risk assessment, so that you can demonstrate that you're keeping an eye on the evolving picture and adapting as necessary. In the case of any visit by an enforcement officer, your risk assessment is the first document they will ask to see. Second, provide adequate ventilation. In my view, this has become more significant over time as the nature of the virus has become better understood. The guidance is telling us all to ensure an adequate supply of fresh air to indoor spaces where people are present. That can be natural ventilation by opening a window, or by mechanical means, or by some combination of the two. But the essential point is that any poorly ventilated space in premises that are usually occupied will require consideration with a view to improving fresh air flow, and a CO2 monitor can be of assistance in identifying whether a space is poorly ventilated. Third action, clean more often. We're all familiar with this messaging, aren't we? You focus on frequent touch points such as door handles and light switches, and ask your staff and your visitors to use hand sanitizer and wash their hands more often. Fourth, support the self-isolation requirements for those with symptoms or those who have returned a positive test, and indeed for anyone directed by NHS Test and Trace to isolate because they've been a contact of someone who's tested positive and aren't themselves exempt. Hopefully you'll all anticipate that the burden around that piece, that expectation, has reduced a little since the self-isolation period reduced to 5 days for those who can test negative via lateral flow on days 5 and 6. Fifth element, this concerns check-in. You all appreciate that it's no longer a legal requirement to collect customer contact details, but there's a gentle encouragement, a gentle nudge here to enable check-in via the NHS QR code poster on the basis that that will assist Test and Trace to contact those who may have been exposed and who may need to book a test. You don't have to ask people to check in, and you're not obliged to turn them away if they refuse to do so. If you are minded to continue with the QR poster, the guidance tells you to have a paper system operating alongside it for the benefit of those who don't use the app. And finally, the sixth element, the sixth of these priority areas, communication and training. It's a customary regulatory expectation. Keep your staff and your visitors up to date about the approach that you're taking to the virus. And I think if you think about all of those steps and record those that you're adopting in your risk assessment, you really will be going a long way to satisfying the expectations of regulators and avoiding enforcement action. Another version of this suite of working safely guidance documents is addressed specifically to events and attractions, and that too I think is likely to be relevant to some of you on the call today. This is briefly captured in the next slide, please. And again, recently updated, records the ending of the legal requirement to check the COVID status of customers, but reflects that you can still choose voluntarily to use the COVID pass should you wish. The contents of this module, very similar to that we just looked at in the hospitality space, features the same 6 priority actions that I think you can usefully adopt as your checklist. So I think stepping back, my overall observation is that for as long as we're faced with some version of coronavirus, and so long as we're seeking to map its risks onto the traditional health and safety template, guidance will continue to play a prominent role in dictating control measures and in indicating the extent of your legal compliance. So engaging with it will have the effect of driving down your enforcement risk. So those are my observations wearing my regulatory hat. I don't know whether, Ben, that attracted any specific questions, but if it didn't, then I think I hand the baton over to Andrew now to speak from a LeedsBID perspective. Thank you very much.
Thanks, Sarah. We're actually over to Richard. You've to talk about
apologies.
Is venue and space planning. Sarah, you might want to tackle this one on the chat, I think, because I'm just conscious of time. But
yes,
one thing that we did have was, should we expect the traditional forms of enforcement to return to pre-pandemic levels as the pandemic tsunami recedes? But if you wanted to deal with that one on the online chat, that would be great. Thanks.
I'll certainly do that. And my apologies, Richard. I'll hand
over to Richard to talk about venue and space planning, which I know is Andrew Cooper from LeedsBID is very keen on this because of all the changes that have happened during the pandemic, with leisure operators expanding into the street and things like that, and being quite creative in the space that they've created. And will we see those things continue? Will planners at the council take a relaxed view of this kind of thing? I think it's a really interesting topic, and I'm interested to see your thoughts or hear your thoughts, Richard.
Fine, thank you very much, Ben. Hello, good morning, everyone. Sophie mentioned a crystal ball earlier in her speech, and I remember when I first came to Leeds many years ago. I worked in a company where there was a young lady who was obsessed with a clairvoyant, and suggested that I ought to go along because I was very cynical, and I did because she paid. And she did have a crystal ball, and her first comments were something along the lines of, "I'm sensing you like pubs and restaurants." And I thought to myself, well, you don't need to be a clairvoyant to state that, because I do. And I think that when the pandemic hit, I think we all thought long and hard about how we do miss pubs and how we do miss restaurants, and the thought of a decent pint and a cocktail that doesn't contain 8 gins and knocks you out in 10 minutes, having one prepared properly, we missed it. And it certainly didn't go unnoticed when I was having my daily walks with my wife, that there were a lot of structures being put out in front of pubs and restaurants. And I know they didn't have planning. Now, ordinarily, and having been in this job for 32 years, authorities would have jumped on that with enforcement action. But what they did, and I thought, the government introduced this guidance and this legislation, rather than asking pubs and restaurants to retrospectively apply for planning permission for these structures, because that would have genuinely taken months. I mean, to put it in context, I applied retrospectively for an awning in July of last year. I still haven't got the planning permission through. It's fine, but we haven't got that bit of paper. So to apply retrospectively, it wasn't really on offer. So what the government did was, in June 2020, they allowed pubs, cafes, and restaurants to erect a movable structure for an unlimited number of days without the need for a planning application. And that's important because, as I say, any structure, and people say this all the time to me, they say, oh, well, it's only temporary. That's irrelevant, because I could build a house and say it's temporary for 20 years and I'll take it down. Once you build a structure or a building, it needs planning. So what the government did was introduce temporary measures, because when pubs were closed and there was the ability to be able to drink outside, or the alternative to drinking inside was to have a safer environment, because people were becoming more aware that COVID was more transmittable inside. People wanted to be outside. And so the government introduced the temporary measure, and it has proved successful. It really has proved very successful. So what they did, and some people don't agree to this, but in December last year, the government said, right, well, we'll make it permanent. You can do it. And so they reintroduced some measures into the General Permitted Development Order. And I'll just read you what it says. This is important. And I'll come on to listed buildings in a minute, because that's important as well, because lots of pubs and lots of restaurants are listed. But it says the provision of one movable structure within the curtilage and for the purposes of a building used for a purpose within a drinking establishment or food and drink. Development is not permitted if you're a Schedule H monument or a listed building. Any part of the structure would be within 2 meters of the curtilage of an adjacent property. If the height of the movable structure is over 3 meters, or if the footprint of the movable structure would exceed the lesser of 50% of the footprint of the building, or 50 square meters. So you can put quite a large structure in place. What it doesn't state in there, which I thought was very, very interesting, there's no reference to noise, and there's no reference to lighting. And in other general permitted development orders and permitted development rights, those items are very much at the forefront. So if you're looking to change the use of an office, for example, under Class O to residential, you have to look at issues such as noise, flooding, and highways. But in this instance, those areas of potential conflict with neighbouring properties, noise and lighting, you don't have to deal with them. What you must do, though, is don't believe that you can do these permitted development rights without checking exactly what you have planning permission for. Because in certain instances, you might have a planning permission for a pub or planning permission for a restaurant with a Section 106 agreement, which stipulates that they've withdrawn your permitted development rights. Or, for example, you put a structure in the car park and you block out a dozen or so car parking spaces. There may well be a condition on the planning permission that states you shall retain car parking in perpetuity. So it's important to check any restrictions on an existing planning permission before you initiate your permitted development. Now, I mentioned listed buildings. for listed buildings, it's the same size of structure, but what you have to do, you can only do it for 120 days within a calendar year. So there is a restriction in that respect. And also you have to apply for what's known as, or check with the council whether you need prior approval. So you have to apply to the local planning authority with your method of construction for your gazebo or marquee, because quite often people overlook the fact that when you have a listed building, it's all listed. So don't be fooled by if you say, well, it's only the outside of the building that's listed, or it's only the windows that have historic context. It's only the front facade that's valuable. That doesn't matter. The whole of the structure is listed. And if you start banging nails or drilling holes into a listed building to erect your gazebo, then you could be prosecuted. So you have to go through a formal process of notifying the planning authority of what you need to do. The drawback of that is that the council has to notify neighbours for 21 days, and they have to notify Historic England for 21 days. And then quite often, because of workloads with councils, it does run right up to the last minute, and they have 56 days within which to determine whether they're happy. After 56 days, you're deemed to have your consent in place. But 56 days is 56 days of trading in summer when we do need to get some trade in place. So if you do have listed buildings and you do want to put up a structure, I would advise you start looking at it now, so you get those applications in and those days under your belt before you erect the temporary structure. I would say that I think that I'm a planner, I'm a town planner, not an architect, not an interior designer, and therefore spatial awareness in bars and pubs. You as operators know more than anyone how to control and how to make the best use of space and make customers feel comfortable. What the government has done with this permitted development and the change in the permitted development order has given a thumbs up to say, look, we're not in the or we would advise planning authorities not to be interested in taking enforcement action. We are looking at making sure that bars, pubs and restaurants can move forward still in uncertain times. I mean, we look at the variants. We don't know what variants are out there in the future, but the government have given a nod and they've said, look, we'll work with you. We'll give you some rights to do what you want to do. I don't know what the future holds in terms of the government giving even more rights to pubs and bars and restaurants, but it's a good start. It's a good first start. They listened, they saw, and they've approved. So I think I'll wind up there. And if there are any questions, please do ask.
Thanks, Richard. Thanks very much. That was really interesting. We have got a quick question in that I'm just going to read off. It's literally just come in. Is planning required still to put up a structure that would allow an outside wedding ceremony to take place, or has this been approved / granted as part of the existing ceremony license? That's quite a specific wedding question. I'll put you on the spot there potentially.
No, it's fine. I mean, there is the ability under normal general permitted development to erect a marquee for 28 days within a calendar year for certain events. I mean, clearly you'll need a license and so on and so forth. I don't think the structures that can be attached to public houses in terms of the size of them will necessarily host a wedding, but you can put a gazebo and you can put a marquee within the curtilage of your pub and restaurant. And so if it fits the size and it fits with the license, why not?
Okay, thanks very much, Richard. Right, I think Andrew, hopefully you're there, Chief Executive of Leeds, to round up our seminar today.
That's very kind of you, Ben. Some interesting discussions, really useful. Hopefully someone give me a thumbs up to say that I'm coming through all okay. Is that, yeah, thank you, Sophie. LeedsBID, we've had a long-standing relationship with Clarion. We used to occupy the same building, and they've been very supportive of the Business Improvement District since its inception, which was 2015. We are the largest business improvement district outside of London. There are 320 in the UK. So for you operators who might be in other cities, you might come across business improvement districts. They all differ in what they have to offer, but definitely worth knocking on their doors and finding out how they can support you, particularly in the leisure sector at the moment in a sort of post-pandemic world, which is what we hope it will be. I'm going to go sort of reverse some of the comments. So I'm going to start with Richard and then work backwards. Very briefly, just summarising some observations and then signposting some areas of support. It's amazing, isn't it? The accelerated change that the pandemic has brought, particularly to that outside space. And we see the operators have quickly got outside heaters and have invested quite significantly. I mean, we're talking not a few plastic chairs, we're talking proper structures and outdoor heaters, and that's really transformed city centres and urban places. I walked past a couple on Sunday, so we're still, February, who were eating their Sunday lunch outside. I mean, you wouldn't have seen that, would you, 2 years ago? Sitting outside under a heater, eating their Sunday lunch in the centre of Leeds. So that's the transformation of the pandemic. I think it's the Norwegians who say there's no such thing as bad weather, only bad clothing. And I think as those structures hopefully become well considered in terms of aesthetically, how they link into the city centre, they can be sort of quite tactical as well in terms of tactical urbanism, how we make the spaces between our buildings animated and well occupied, very sort of continental, and businesses in the centre have embraced that and making sure the legislation is right and working within the parameters. But I sense that the local authority in Leeds has been very accommodating, linking into some of the comments that Richard has made. And I think long term, if you're a business that has 30 covers inside and you've got 30 covers outside, and let's hope that all them covers are occupied, then you're going to be employing more staff and growing your business. So these are good positive things that I hope will last. And then going to Suzanne's comments about recruitment. I mean, recruitment is really challenging because if you're going to look for a job, you then sort of think, well, look at the sectors that have had a wobble. Is that secure? Am I going to get I might as well go to another sector where it's more stable. So recruitment for the hospitality sectors, as Suzanne pointed out, you've got to work a little bit harder. And we recognised that during the pandemic, and 12 months ago, we established the Engine Room. And the Engine Room's on Albion Streets in City Exchange. It's a free resource to businesses in the centre of Leeds. It's run by Diane Wainwright, who's on the webinar this morning. And I would extend that to all businesses, to legal firms, to leisure operators. Utilize that facility. There is a studio in there. There is training rooms. There are courses that we put on, and we specifically did that. We launched the Engine Room to support businesses in a free capacity to help them as they recover during the pandemic. So lots of resources, free resources and events there, and more businesses like Clarion are partnering with the Engine Room, and maybe the next one, Ben, will be in person, looking out over the city. And I think that's what we want to do is provide that opportunity for people to sort of work together and network, particularly around some of the skills issues and recruitment. We did our first job fair before Christmas. There were nearly 300 people went through it, 35 employees putting on stalls and stands, and it was very successful, and something that Diane, I know, is working on again. So if there are areas of support which you need from the bid through the Engine Room or practically, then do come back to us and say, we need some help here. On a practical front, when we come back into the city centre, and as we've seen from the leisure sector, chairs and tables are outside. Sometimes they're taken back in and then brought outside. Gets messy. So our street rangers, we've enhanced that service. So you'll see the street rangers, they've got new Whizzy kit, which is all very green and electric, and Euro 6 engines and all of that. But their service is increased significantly. And our board have said, which is a board of all different sectors of the business community, have said we want the bid to increase that service to business because it's important we don't forget the basics. which is making sure the place is clean, it's safe, and it's friendly. So tap into that service. The Rangers, just email inquiry@leedsbid.co.uk. They'll come out early in the morning. They're in at sort of 6, half 6 and they're in till late as well. So if you need some sort of practical cleaning around your business, it's important we keep things clean. And then finally, because I know we're running a little bit over, Ben, in terms of the grants that are still available, if you don't get our newsletter, I'm sure Sophie or Suzanne will circulate, or Ben circulate the list of attendees, but make sure you get our newsletter. We're not selling you anything. We're just telling you what's going on in the city centre. Our only interest is to see businesses improve, hence our title. We're not political, we're not for profit. We just want to support businesses, and we send a newsletter out fairly regularly with what's going on in the city centre. And I noticed in our newsletter this week, there's still grants that have not been claimed by certain businesses, which might help some of the points from Sophie was making about sort of landlords and rent and supporting businesses. So there's still pots of money there to assist you. Interesting point Sophie made about footfall. Footfall is coming back into the city centre. And I was speaking to Hammerson's and Land Securities, both FTSE 100 companies, both got food offers, and we're seeing footfall increase. And not only that, we're seeing spend increase. And I think that's really important as people come back into the city centre. And I put in my chat, in the chat about the investment in the city centre. I think people are investing and looking at the long game. If you go into Trinity Kitchen, you'll see that's been transformed during the pandemic. We're seeing down on Vicar Lane, the Ivy expansion that's happening there, more retail and hospitality. Yes, definitely retail has shrunk, but we're seeing some new investment of hospitality in the city during the pandemic and even beyond now, which is encouraging that people are choosing Leeds. We're a compact city. We've got high footfall. There's good loyalty in terms of customers in the city centre, and I think that presents good opportunities for people who are looking to invest. So if you've not been in the city centre for a while, come in and you'll think, oh, that's new, and that's really, really encouraging. So footfall, still some challenges. I think back to Sophie's point on footfall, there's certain sectors are still. Some are right, let's get back in. Others are, we're taking it a bit more slowly, which is understandable. We've been through a pandemic. It's a bit like riding a bike. We have a bit of a wobble, don't we, as we're getting back into things. And what I'm noticing is I'm gradually starting to go into businesses, particularly from the commercial sector that have been away, the professional sector, sorry, that have been away and working from home. I'm at an event this afternoon in KBMG, which employ 836 people in Leeds. And you sort of think they're doing an event. So it's encouraging that people are starting to come back, which has a positive knock-on effect to transport and the fact that you buy a coffee on the way in and the social responsibility, but also sort of network and well-being. And then a lot of our courses on the engine room have been around well-being and mental health and so on. So do tap into those for your own personal and professional development. There's lots of resources there to help. So yeah, I found it very interesting this morning. I hope that's a useful sort of summary. And when you come into the city centre, I'm back to Richard's point. I think this is an opportunity to transform Leeds in terms of its outside space. When you look at what's happened on Greek Street and compare that to 3 years ago, the outside space there is quite fantastic. And they had lovely purple lights at Christmas. Transforming those spaces, I think there's a real opportunity because a rising tide raises all boats. And for Sophie, probably raises rents as well. And that's really important. So I think that's important in terms of investment in the city centre, that we take these opportunities. I'll stop talking. Is that helpful? Getting a nod, really maybe.
That was a very professional summing up, much better than I could have done. So thank you very much indeed for that. So I mean, I think on that note, I think there's a lot to be positive about, and it'll be interesting to see the development of Leeds City Centre, how it pans out over the next 5 years or so, and indeed, the other centres around the region and beyond. So thank you very much to everyone that's spoken today. Really appreciate it, and thank you very much importantly for everyone that's joined in. As I say, any questions at all, please do not hesitate to get in touch with us. We'd be delighted to discuss anything that has arisen from this morning. And Have a good rest of the day, and thank you once again for joining us. Bye-bye.